Hi, everyone. I'm Katie Couric. Welcome to Eye to Eye. The storm surrounding the dismissal of 8 U.S. attorneys continues to plague the White House. Prominent Democrats accuse the administration of playing politics with crucial law enforcement positions. In an exclusive interview, one of those 8 attorneys, John McKay, tells Sandra Hughes he thinks the firings have done lasting damage to the integrity of the Justice Department.
My entire office and myself had been evaluated by the Justice Department, a very large team throughout 2006, from March to about September of 2006, and both I and my management team and all of the hardworking men and women in my office were highly evaluated by the department. So I knew there were no issues with regard to my performance, and they gave me no performance issues at the time of that I was asked to resign. Much to my regret, both the Attorney General and the Deputy Attorney General testified in Congress that some of us, including myself, were dismissed for performance-related reasons. And I knew that was false, and I felt obligated to speak up on behalf of not just myself, but on behalf of the men and women in my office and the special agents who do the investigations. I knew their work was good. I knew there were no performance issues on their part, and I felt it was my duty to speak out on their behalf. All 8 of the United States attorneys that I know of who were fired, 7 of us on the same day, December 7th, were in a conference room with all 93 United States attorneys and the Deputy Attorney General of the United States, who stood in front of us and told us we were the greatest class of United States attorneys in the history of the government. And he must have been carrying around in his briefcase a list of 8 or more United States attorneys that he intended to fire the very next day. Well, I don't think any United States attorneys were aware of any lists being maintained by certain officials at our headquarters in Main Justice. I've since now learned, really just in the last couple of days, that individuals working for the Attorney General were preparing lists. I don't know what their criteria was. I don't know what their process was. It certainly seems to have ignored the formal review process under which we all operate. And, you know, I think the real problem with the lists is they've opened the Department of Justice to criticism that politics is involved in the work that we do. I am really proud of the work that was done in my office and the excellent run that I had, 5 years as United States Attorney, and a lot, as you pointed out, a lot of very, very good cases. I think the real problem here is that the work of those people who are still there, both in my office in Seattle and Tacoma, but also around the United States, now have to defend the work that they do from charges that politics may enter into the investigations that they undertake, the appearances they make in front of grand juries, the appearances they make in front of juries when they have to try cases. I believe in the integrity and in the competence of United States attorneys and assistant United States attorneys around the country, and I don't think that has changed. What has changed is that the Attorney General and apparently the White House have now allowed speculation about political motivation to be the topic of the day. That is a black cloud really on the Department of Justice, and really the Attorney General must dispel that. You know, I think that the work being done by United States attorneys and assistant United States attorneys around the country is going to continue to be excellent. They now have a new burden that they're carrying. I hope it doesn't stay with them very long. I'm replaceable. I know that. Others can do the work that I was doing. Any individual prosecutor is replaceable. What's not replaceable is our reputation for fairness, our reputation for independence from political influences. We've earned that over time, and I resent very much the idea that the current leadership would allow that to be injected into the work that we do. I did apply to be federal judge last fall, and at that time questions were directed to me about the 2004 governor's election in Washington State, a very close election, many allegations of fraud. On 3 recounts, the Democratic candidate was elected, and while there were claims of election fraud, no evidence was ever developed to indicate that a crime had occurred. And I, at that time, made a decision not to pursue further federal investigation. This was a very controversial thing, and I learned when applying to be a federal judge last fall, 2 years after the election, that some in Washington State were very resentful that I hadn't intervened in the election, which would have been terribly inappropriate. There is no question that my office's handling of the inquiry in the 2004 governor's election went very smoothly. We complied with all of the requirements of the Civil Rights Division, the Voting Rights Section, and no one ever communicated to me that they were unhappy with any step I had taken. I would like to say that had someone come to me and indicated that they wanted a full-blown criminal investigation in front of a grand jury, whether it be the White House or the Justice Department, I would have refused. And I would have refused because there was no evidence. Had I been ordered by the White House or the Justice Department to drag innocent people in front of the grand jury, I would have resigned.